Excuse me.
Good morning. Are you Ray LeBlanc?
Yes, ma'am.
Can you hear me okay like that?
I can hear you.
Okay. And will your client waive the formal reading of the indictment?
Yes, Your Honor.
Mr. LeBlanc, in cause number 250460, you're charged with the state jail felony offense of burglary of a building from February 5th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with? Did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
Do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And are you a U.S. citizen?
Yes, ma'am.
Okay.
You're a U.S. citizen.
Oh, yeah.
Okay. I have to ask everyone.
Yeah.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. LeBlanc is not competent?
No, Your Honor.
You're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of burglary of a building. Sentence you in accordance with your agreement to a term of 6 months in the Jefferson County Jail under Section 1244 of the Penal Code. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows that this was an agreement that I followed, so you've waived your right to appeal. I am also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition.
Okay.
Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you.
Never owned a firearm in my life.
I got to say all these words, sorry. So you should read that to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Ms. Holmes.
Okay.
Good luck to you, sir.
Thank
you, Ms. Holmes.
Yes, ma'am. Thank you.
Good morning, sir. Are you Derek Ardwan? And will your client waive the formal reading of the indictment?
He does.
Mr. Ardwan, in cause number 250350, you're charged with the second-degree felony offense of sexual assault, and that's from July 15th of 2023. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, you will be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a cap of 6 years in prison, which means if I accept this agreement, you're leaving your punishment up to me. And I cannot give you more than 6 years. I could give you 6 years, I can give you less. It'll depend on the information that is to decide if you're guilty or not. And then if they find you guilty, you can leave your punishment up to them. If we go forward this way, you're waiving that right. And is that what you want to do? Also, do you understand that if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? Also, as a result of this plea, it looks like you have gone over with your attorney that you will be required to register as a sex offender, and it looks like you've already signed that document and those admonishments. Is that your understanding as well? State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Ardwan is not competent?
No, Judge.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back later for sentencing. Anything that you think is important for me to know, get that information to Mr. Lewis, and he will present it to me on your behalf when we come back. All right? You can go back with the bailiff. Mr. Johnson, in cause number 242044, you're charged with a first-degree felony offense of arson, intending damage to a habitation or a place of worship from August 1st of 2024. And how do you plead to that charge? And are you pleading no contest freely and voluntarily? I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Perazzo?
Yes.
Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 5-year defense. Any fine?
No fine, Judge.
Is there restitution?
We're gonna I don't believe there is any. It doesn't appear that there is that has not been already satisfied, but just to be on the safe side, we'll take a look at that.
Okay.
Dependency PSI if we may.
All right, is that your understanding of your agreement? Do you also understand that if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Johnson is not competent? All right, sir, I'm going to find that you entered your plea of no contest freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report, and that'll give me more information about you, your case, and then we will come back at a later date for sentencing. All right, you can go back with the bailiff.
Thank you.
Good morning, sir. Are you James Burrell?
Yes, ma'am.
And Mr. Lewis, will your client waive the formal reading of the motion?
He does, Judge.
Mr. Burrell, in clause number 22-39838, I have a first amended motion to revoke your community supervision. Shows that you were placed on probation May 23rd of 2023 for the third-degree felony offense of theft, and that was a 10-year term in prison that was suspended for 10 years. Is that correct? The motion alleges that you violated your probation. Count 1 alleges that you failed to report as directed to the probation department May 14th, May 23rd, June 11th of 2024. And is that true or not true? Count 2 alleges that you failed to immediately report to your probation officer your change of address and phone number. Is that true or not true? I'm sorry? Okay.
I think the state would be willing to waive counts 3 through 5. However, we would be asking for some sort of a plea on 6 and 7.
All right, so the state's going to abandon 3 through 5. Count 6 alleges that you were arrested for the offense of possession of a weapon by a felon June 19th of 2024 in Orange County, Texas. And is that true or not true? And then count 7 alleges that you were arrested for possession of a controlled substance June 19th of 2024 in Orange County. Is that true or not true? Did you enter your pleas of true to, I'm sorry?
No.
Oh, I thought I was going to say. Did you enter your pleas of true to counts 1, 2, 6, and 7 freely and voluntarily? And did you plead true to those counts because they're actually true? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Burrell is not competent?
No, Judge.
All right, sir, I'm going to find that you entered your pleas of true to counts 1, 2, 6, and 7 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, and at this time, revoke your probation. Reassess your punishment in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. I went over that with you back when you first got probation, right? So just make sure you read that and know that because of this judgment, you cannot possess a firearm.
What we just witnessed inside this Texas courtroom is a striking reflection of how justice works. Methodical, precise, and at times merciless. Each case might look routine on the surface, but beneath the formalities lies a story of choices, consequences, and how one decision can reshape a person's entire future. Let's start with Ray LeBlanc. Charged with burglary of a building, he pled guilty to a state jail felony, a serious but lower-level offense under Texas law. His 6-month sentence might seem lenient, but the impact goes far beyond jail time. By law, Ray now loses his right to possess firearms, permanently under state statute. This is a key detail many overlook. Even a single felony conviction, no matter how small, triggers a lifetime federal firearm restriction unless rights are specifically restored. The judge made sure Ray understood every line of that deal, Lars, because once he said guilty, there was no going back. Next, Derek Ardwin's case raised the stakes. A second-degree felony sexual assault charge and a cap plea, meaning he agreed to plead guilty, but the judge decides his sentence capped at 6 years. That's a risky move. Why? Because it hands all discretion to the bench. No jury, no appeals. It's a legal gamble defendants sometimes take when they hope their cooperation or clean record might persuade the court toward leniency. But the emotional gravity here is heavy, Mike. A conviction of this nature comes with mandatory sex offender registration, a lifelong label that follows you even after release. Then came Mr. Johnson facing a first-degree felony arson charge, Bryce, one of the most severe property crimes under Texas law, especially when it targets a home or place of worship. Yet he pled no contest and received deferred adjudication. This means he avoids a conviction for now. If he follows every rule of probation, he can walk away without a felony on his record, but one misstep, one violation, and that deferred status disappears, converting instantly into a full conviction. It's the court's version of mercy with a warning label. Finally, James Burrell's case, and the harshest moment of all. Once on probation for theft, he was given a second chance to prove he could reform. But multiple violations, including a new weapons charge and drug possession, tore that deal apart. When probation is revoked, the court doesn't start over. It simply enforces the original sentence that had been suspended. In his case, 4 years in the Texas Department of Corrections. What was once freedom on conditions became full incarceration. The judge's tone said it all. Calm, firm, final. What ties all these cases together is accountability. Every one of these defendants had a chance. Some through plea deals, others through probation or deferred sentences, and yet the system's balance is unwavering. Compliance earns leniency. Violation brings the hammer down. These hearings also highlight the transparency of justice. Every admonishment, every waiver, every yes ma'am is on record to ensure no defendant later claims they didn't understand their rights. It's a procedural shield, not just for the court, but for the integrity of the justice system itself. Watching these moments unfold reminds us that behind every case file is a person standing at a crossroads. Some walking toward redemption, others back into the system. And that's what makes these courtroom scenes so raw, so real, and so human.